May it please the court, I appear on behalf of the applicant.
Thank you.
Chief Justice, members of the court, I appear on behalf of the respondent, Mr. Makati.
Thank you, Mr. Marcus.
This is an application for leave to appeal against a judgment of the Supreme Court of Appeal handed down on 6 February 2024. This application is yet another instance of the unending litigation between Vodacom Pty Ltd, the applicant, and Mr. Nkosana Kenneth Makate, the respondent, a former employee of Vodacom. The litigation, which spans just under 2 decades, concerns compensation owed by Vodacom to Mr. Makate for the Please Call Me PCM idea. The first round of litigation culminated in a judgment in which this court in 2016 declared that Vodacom was bound by an agreement concluded by Mr. Makate and Mr. Philip Geisler, the then Director of Product Development and Management at Vodacom, in respect of the PCM idea B, ordered that Vodacom and Mr. Makate should negotiate in good faith to determine reasonable compensation payable to Mr. Makate in terms of the agreement. And C, directed that in the event of disagreement on reasonable compensation, Vodacom's Chief Executive Officer, the second respondent, would break the deadlock and determine such compensation. The second and current round of litigation commenced as follows. Negotiations between Mr. Makate and Vodacom were unsuccessful, and the matter was referred to the CEO after a thorough going process. No, I think my law clerks gave me a wrong hand-down note. Apologies for that. The second and current round of litigation commenced as follows. Negotiations between Mr. Makate and Vodacom were unsuccessful, and the matter was referred to the CEO. After a thoroughgoing process, the CEO determined that 47 million rand was reasonable compensation for Mr. Makate. Dissatisfied, Mr. Makate took the CEO's determination on review to the High Court of South Africa, Gauteng Division, Pretoria. The High Court found in Mr. Makate's favor and ordered a remittal of the determination to the CEO subject to certain parameters. Vodacom appealed to the Supreme Court of Appeal, which dismissed the appeal. The Supreme Court of Appeal also substituted the High Court order with its own. A part of the Supreme Court of Appeal order that is worth highlighting is a portion that read as follows, I'm paraphrasing. Mr. Makate was entitled to 5% to 7.5% of the total revenue share of the PCM product, together with moral interest thereon. Alternatively, interest in terms of the prescribed rate of interest Act 55 of 1975, and that the total revenue of the PCM product should be calculated according to the computation models for compensation proposed by Mr. Makate. Vodacom has now appealed to this court. Its main argument against the Supreme Court of Appeal's judgment is twofold. First, the Supreme Court of Appeal acted beyond its jurisdiction by substituting the High Court order with an order of its own in circumstances where Mr. Makate had not cross-appealed against the order of the High Court. The Supreme Court of Appeal thus determined an issue that was not before it in breach of the rule of law and the right to a fair hearing protected in Section 34 of the Constitution. Second, continues the argument, there were several seriously disputed issues in respect of which swaths of evidence were adduced and written and oral argument presented by both parties, all of which were disregarded or misunderstood by the Supreme Court of Appeal. This, according to Vodacom, amounted to disregarding the true issues that had to be decided by the Supreme Court of Appeal. Vodacom concludes this second argument by submitting that the Supreme Court of Appeal's disregard of the real issues on appeal constitutes a total failure of justice in breach of the rule of law and violates Vodacom's constitutional right to a fair hearing. Mr. Makate counters that Vodacom's application does not engage this court's constitutional or general jurisdiction, and that therefore we must not entertain it. Mr. Makate argues that the Supreme Court of Appeal did not exceed its jurisdiction as the substitution issue was pleaded before the High Court and as it was relevant to the proceedings before the Supreme Court of Appeal. As a result, the appropriateness of that substitution was fully ventilated by the parties before the Supreme Court of Appeal. Mr. Makate further argues that the Supreme Court of Appeal did not disregard or misconstrue the evidence or issues that it had to decide. The judgment of this court penned by me is unanimous. It is concurred in by Maya C.J., Majid J., Matopo J., Nhlanhla J., Rogers J., Sigobin A.J., Theron J., and Chiqui J. This court has agonized over Vodacom's submission about a court's disregard of facts giving rise to a total failure of justice. How flawed must an assessment be for it to cross the line to constitute a failure of justice and thus a violation of the rule of law and the right to a fair hearing guaranteed in Section 34 of the Constitution. Put differently, what is the threshold above which our constitutional jurisdiction is engaged? In what circumstances does the assessment fall short of that threshold so as to be hit by the Busak or Mbata principle to the effect that dissatisfaction with a court's assessment of facts does not engage our jurisdiction? On the face of it, Vodacom's argument seems to take us to a slippery slope that will result in the reach of the Busak and Mbata principle being difficult, if not impossible, to implement. Will that principle not be unacceptably attenuated? Whatever the attendant difficulties, is the real question not whether there has been a total failure of justice? In this context, I am not concerned with esoteric debates about what justice is. I am concerned with justice in the sense of a reasonable expectation that within the bounds of human fallibility, courts will do what is expected of them. justice, and indeed the court process are not about perfection. Courts are not to be held to some abstract standard of perfection. It is unsurprising that in the case of Bennett, this court held that judicial officers are not superhuman beings who do not make mistakes. This is why there is an appellate process to correct mistaken findings on law or facts. But there are errors in the assessment process that are so fundamental as to go beyond this ordinary level of human fallibility. And those are errors that are so far-reaching as to result in a total failure of justice, in the sense that a court ends up failing fundamentally to decide the case before it. It fails totally to consider the case before it. This I call the duty of proper consideration. This duty is closely related to the duty to give reasons. That is so because it is in the reasons or lack thereof that we can assess that there has been a failure to discharge the duty of proper consideration. It should matter not that this failure may manifest itself through an improper factual assessment. What is important is that the flaws in the assessment must be so fundamental and pervasive as to vitiate the court's judgment. Once vitiated by flaws of this nature, a court's decision is a non-decision. Without a decision, a court will have failed in its very raison d'etre. Is there support for this proposition? Definitely not in South Africa. This is new ground within South Africa's jurisprudence. What about elsewhere then? Authority that is on point is to be found from the jurisprudence of the European Court of Human Rights, the ECHR. On point because the jurisprudence also deals with the right to a fair hearing contained in Article 6.1 of the European Convention on Human Rights, which protects the right to a fair hearing. In Zaidov versus Azerbaijan, the ECHR held that the convention is intended to guarantee not rights that are theoretical or illusory, but rights that are practical and effective. The right to a fair trial cannot be seen as effective unless the requests and observations of the parties are truly heard. That is to say, properly examined by the tribunal, close quote. I accept this holding. This holding ties in with Vodacom's complaint that the Supreme Court of Appeal did not truly hear or properly examine the facts and issues before it. The question that remains is whether there is substance in Vodacom's claim. But before going there, let me caution that unsatisfactory or even incorrect reasoning and defects in a judgment do not necessarily equate to a failure by a court to discharge its duty of proper consideration. The duty of proper consideration is about the substance of a judgment viewed holistically. Flaws in the assessment during the adjudicative process that are so fundamental and pervasive as to vitiate the court's judgment constitute a failure of justice and thus a breach of the rule of law and the fair hearing right guaranteed in Section 34 of the Constitution. Let litigants be warned that this conclusion is not an open sesame for them nitpickingly to take every and any point on the court's assessment of facts and issues. Back to the question that remains. Did the Supreme Court of Appeal's assessment of the facts and issues constitute a failure of justice? At times, the Supreme Court of Appeal judgment is characterized by confusing reasoning. At other times, it is characterized by statements that evince a disregard for or lack of awareness of the facts and issues. There are several examples illustrating that the Supreme Court of Appeal breached its duty of proper consideration. They are dealt with fully in the judgment, an exercise which cannot be done in this summary. I will illustrate with a few. A ready example is the question whether the 47 million rand awarded by the CEO was inequitable, was central to the Supreme Court of Appeal's determination against Vodacom. This question concerned whether the award of 47 million rand was manifestly unjust or patently inequitable. If the Supreme Court of Appeal found that the CEO's determination was inequitable, then Vodacom's appeal had to fail. This is how material this issue was to the Supreme Court of Appeal's determination. Despite the centrality of this issue, the Supreme Court of Appeal merely highlighted the parties' arguments in respect of this issue and did not engage with or pronounce upon those arguments in any meaningful way. Further, the Supreme Court of Appeal failed to decide the question whether Vodacom's determination was in fact inequitable. A shortcoming of this nature on such a crucial issue constitutes a breach of the duty of proper consideration. Moving on, in his determination, the CEO extensively dealt with evidence on PCM revenue in the context of Vodacom's voice revenue. As part of this, he referred to calculations of voice revenue in one of Mr. Makate's models and said those calculations or estimates need to be carefully examined. And indeed, he examined them carefully. Despite all this detail in the CEO's assessment, the Supreme Court of Appeal held that the CEO's conclusion was reached, open quote, without saying why, close quote. This is evidence that the Supreme Court of Appeal should have been aware of and assessed. Another example that I must touch on is the apparent readiness of the Supreme Court of Appeal to accept whatever Mr. Makate said with regard to the calculations. This is evidenced by the manner in which that court adopted Mr. Makate's computation models for compensation. The Supreme Court of Appeal said that, open quote, absent any evidence that Mr. Makate's computation is wrong, I can find no reason why Mr. Makate's computation should not be accepted as correct. This is surprising given that Vodacom submits that the entire debate in the Supreme Court of Appeal turned on the question whether the models presented by Mr. Makate or those of the CEO should be preferred. And unsurprisingly, because that is what the case and indeed the appeal were about, everything about Vodacom's case was about demonstrating that Mr. Makate's computation was wrong. So there was evidence that sought to demonstrate that Mr. Makate's computation was wrong. Whether or not Vodacom succeeded in this regard is something else and on which we do not have to make a pronouncement. The point is that the Supreme Court of Appeal did not consider this evidence at all. Here is the final example. The Supreme Court of Appeal also appears not to have considered the substantive content of the substituted order it granted in favor of Mr. Makate. The Supreme Court of Appeal simply copied paragraph 2 of Mr. Makate's High Court notice of motion verbatim, thus incorporating the revenue sharing range of 5% to 7.5% and two alternative rates of interest, mora interest or interest in terms of Section 2A5 of the Prescribed Rate of Interest Act. The alternatives in the order translate to huge differences in the amounts payable across the revenue sharing range and between the interest calculated on the alternative bases. If the Supreme Court of Appeal had properly considered the relief, it would have realized that although a litigant can claim relief across a range or in the alternative, a court has to fix the relief with precision. The purpose of giving these few examples is to illustrate that the Supreme Court of Appeal, A, failed to provide adequate reasons for its judgment, B, disregarded or was unaware of certain material facts and issues before it, C, at times merely highlighted the parties' arguments in respect of central issues but did not engage with those arguments in any meaningful way, D, failed to assess evidence that was adduced by the evidence which it ought to have assessed, and E, readily accepted whatever Mr. Makate proffered without explaining why it did so. Based on these holdings, I conclude that the Supreme Court of Appeal failed to discharge the duty of proper consideration. This failure violates the rule of law and the fair hearing right protected in Section 4 of the Constitution. Must we deal with the ground of appeal on the lack of a cross appeal? Ordinarily, we would not have to. That is so because what I've just held on the failure of justice point is dispositive of the appeal. But I feel that this court must have the last word on this ground. That is so because the manner in which the Supreme Court of Appeal dealt with the issue underlying this ground, i.e. upsetting the order being appealed on an issue in respect of which there was no cross appeal, will be considered binding
Justices of the Constitutional Court and the Supreme Court of Appeal, Judges President and Deputy Judges President, esteemed members of the Judiciary, retired Chief Justice of the Republic of South Africa, Justice Zondo, retired Deputy Chief Justice Museneke, and all the retired justices of the Constitutional Court in attendance, retired Deputy President of the Supreme Court of Appeal, Justice Petse, Advocate Nzebeza SC, Judge of the African Court on Human and People's Rights, National Director of Public Prosecutions, Advocate Batohi, heads of Chapter 9 institutions, Acting Secretary General of the Office of the Chief Justice, and other Directors General present here today, members of the legal fraternity, distinguished guests, and last but certainly not least, our guest of honor, Acting Deputy Chief Justice, Justice Mbuyiseli Madlanga. Justice Mbuyiseli Madlanga, his wife, Mrs. Nosisi Madlanga, and the Madlanga family. Good morning. On behalf of the South African Judiciary, I'm honored to welcome you all to this special ceremony which has been convened to celebrate the illustrious career of a revered justice of this court and a truly remarkable individual, Justice Mbuyiseli Madlanga. It is with a deep sense of pride, albeit tinged with sadness, to have the privilege of addressing this prestigious event, to honor the valuable contributions made by Justice Madlanga in the South African legal field and beyond her borders, as he embarks on a well-earned retirement from the bench after 17 years of service as a judge of the Republic of South Africa. To you, our esteemed guests, members of the legal fraternity and friends of the law, we extend our heartfelt appreciation for gracing this occasion with your presence. Your attendance is testament to the profound respect and admiration we all hold for the man in whose honor we have gathered, and the significant impact he has had in South Africa's legal landscape and our private lives. We also acknowledge the family of Justice Madlanga, who have firmly stood by him and shared him with the nation over these many years of his service to his country. Behind every great individual is always a family whose sacrifices often go unseen but are deeply felt. Today, we also take a moment to acknowledge and celebrate their vital role, which has undoubtedly contributed to Justice Madlanga's remarkable career and life journey and achievements. We kickstarted these proceedings with the beautiful and deeply touching farewell dinner we had last night, and now following the delivery of Justice Madlanga's swan song, the last judgment he will ever deliver as a justice of this court, and perhaps any court at all in this lifetime. We begin the second stage, the special ceremonial sitting. In tribute to a distinguished jurist, all of us on this bench are proud to call a colleague and brother who has made an indelible mark in our judiciary and nation. This gathering is more than a formal farewell ceremony. It's a moment of collective reflection on a distinguished career and what it means to serve in the highest echelons of the judiciary. The Constitutional Court is no ordinary court. It is the custodian of our democracy, the final bastion of justice, and the embodiment of the hopes and dreams of millions of South Africans and everyone who lives in this country. To serve here is to breathe life into a constitution born from great struggle and sacrifice, and to ensure that its promises are not just words on paper, but lived reality for all, to bear the weight of history. And Justice Madlanga has rendered this service and carried this immense responsibility with absolute distinction. Justice Madlanga's career is not just a chronicle of personal achievement, it's a tale of how one individual's dedication to justice can shape the destiny of a nation. Justice Madlanga was born on 27 March 1962 in Njijini administrative area, a small rural village situated in Mount Frere in the Transkeian Pundus of the Eastern Cape province. In a profound prophecy, he would become exactly what he says his late father imagined for him. And as he tells the story, I quote, "It was my late father who triggered in me an interest in law. In my last year of high school, he mentioned the possibility that if I studied law, I might end up becoming a judge. The idea appealed to me and I registered for a law degree the following year, and I was hooked," close quote. And the boy from dusty Njijini would blossom into a towering legal intellect to become a justice of the highest court in his land and an eminent scholar of international repute. Justice Madlanga's story is one of triumph over circumstance, of brilliance tempered with humility, and of a relentless pursuit of justice. From his humble roots, he ascended to the pinnacle of the legal profession, not through privilege, but through sheer intellect, hard work, and an unshakable belief in the transformative power of the law. His academic journey was nothing short of extraordinary. After matriculating from Maria Zell High School in Matatiele in 1979, he obtained a B.Juris degree at the University of Transkei in 1983. As a law student, he distinguished himself as the best in his class, earning the prestigious Juta Prize. This streak of excellence was a sign of things to come and would define his career. Immediately after completing his LLB degree at Rhodes University, he lectured part-time at the University of Transkei Law Faculty while working for the Department of Justice. His pursuit of knowledge took him across the globe to the University of Notre Dame in the United States of America, where he obtained an LLM cum laude, further solidifying his reputation as a legal scholar of the highest caliber. Justice Madlanga's legal career resumed in 1991 when he returned to South Africa to do his pupillage at the Johannesburg Bar, after which he opened his practice as an advocate at the Mthatha Bar. At the age of 34, he made history as South Africa's youngest judge, appointed to the Mthatha High Court in 1996. It was evident even at that early stage that the judiciary had gained a future luminary. Within 5 years of his appointment, he was afforded acting stints at the Supreme Court of Appeal between 1998 and 1999, and at the Constitutional Court between 2000 and 2001. During this period, he was also appointed as the acting judge president of the Mthatha High Court, and this is where he showed his strong leadership and administrative skills. His early judgments already reflected a keen legal mind, one that balanced precedent with progressive interpretation, a hallmark of his later work in the Constitutional Court. Though personal circumstances briefly took him back to the bar in 2001, where he displayed his prowess as a formidable silk, his return to the judiciary in 2013 as a permanent justice of the Constitutional Court marked the beginning of a new chapter, one that would see him shape some of the most groundbreaking legal principles of our democracy. During his tenure at the Constitutional Court, Justice Madlanga has written more than 60 judgments, including dissents and concurrences. More than half of these judgments were unanimous, and in the rest, he mostly commanded the majority, which shows his ability to achieve consensus and pull his colleagues along with him. Justice Madlanga's jurisprudence is a masterclass in legal reasoning, social justice, and constitutional fidelity. His judgments have not only clarified the law, but have actively dismantled systemic injustices, ensuring that the Constitution's promise of dignity, equality, and freedom is realized for all. I mentioned just a few of his judgments. Banywa versus Master of the High Court, which affirmed the rights of women in permanent life partnerships to claim maintenance and inherit from their deceased partners. There, he declared unconstitutional provisions of the Maintenance of Surviving Spouses Act and the Interstate Succession Act because it infringed on the rights to dignity and equality of women in life partnerships. In reaching this conclusion, Justice Madlanga faced powerful dissent from other members of the court and had the unenviable task of having to interrogate and depart from this court's earlier decisions. Banyua demonstrates his courageous commitment to the protection of vulnerable groups and his recognition that the law must evolve to reflect the lived realities of those it serves. The legacy of apartheid has had a lasting impact, leaving many South Africans in poverty and without secure land tenure. In our democratic dispensation, access to secure land and housing is an important constitutional imperative, essential not only for socio-economic stability, but also for upholding human dignity. The judgment Daniels versus Kribande involved a labor tenant who wanted to renovate her dwelling to make it more habitable. Justice Madlanga analyzed the historical relationship between farm workers and the land they occupied and foregrounded human dignity as an essential component of security of tenure. Few judges have written as movingly about the concept of dignity. His judgment was a powerful declaration that the law must protect the vulnerable, not just in theory, but in practice. In New Nation Movement NPC versus the President of the Republic of South Africa, he wrote a judgment that reshaped our democracy, enabling independent candidates to stand for national and provincial elections. This decision was a triumph for political inclusivity and participatory democracy. Through his reasoning, Justice Madlanga reminded us that the legitimacy of our democracy depends on the openness of its doors and the diversity of voices it welcomes. There are many more seminal judgments which Justice Madlanga has written. Helen Suzman Foundation versus Judicial Service Commission, which was a significant step towards promoting transparency and accountability in the judicial appointment process, as he ordered the disclosure of the Judicial Service Commission's deliberations during the selection process. He has also played a vital role in modernizing the law by abolishing delictual claims for damages for adultery from a third person in DE versus RH, a judgment which reflects a shift in the law to align with modern perspectives on marriage, privacy, and freedom of association. He also affirmed the importance of prosecutorial independence as a constitutional principle that ensures that the National Prosecuting Authority effectively discharges its mandate in the administration of justice. Corruption Watch, NPC, and others versus the President of the Republic of South Africa. In that matter, he declared provisions which permitted the President to extend the term of office of the Director of National Public Prosecutions and suspend the National Director of Public Prosecutions with or without pay for an indefinite period, unconstitutional, thus reinforcing the independence of the NPA and the importance of safeguarding the integrity of the criminal justice system. The list goes on. But quite apart from the impact of his judgments, Justice Madlanga's writing style, which has as its hallmarks elegance, clarity, and simplicity, is worthy of mention. As he remarked in Banyua, we should be wary of adopting a position of an armchair pontificator who is divorced from the realities on the ground. This demonstrated his sensitivity to the lived experiences of those most affected by the law, which must be central when judges write judgments. He has written not merely to decide cases, but to teach, to persuade, and above all, to do justice. Through his pen, the Constitution has found one of its most principled and eloquent interpreters. Beyond the bench, Justice Madlanga's contributions extended to international law, where he represented our country in the International Court of Justice's matter of legal consequences of the construction of a wall in the occupied Palestinian territory, a case that underscored his global stature as a jurist. His contributions addressed a wide range of issues in international humanitarian and human rights law. The resultant ruling of the ICJ stands as a pivotal interpretation of international law, offering a normative framework that envisioned to resolve the conflict between Israel and Palestine, and has mobilized civil society to take meaningful action in support of enforcing international law. Justice Madlanga's impact has not been confined to the courtroom. As chief evidence leader in the Marikana Commission, he brought clarity and compassion to one of the most painful chapters in our democracy. His leadership ensured that the voices of the victims were heard and that accountability was pursued with rigor. His tenure as chairperson of the Exchange Control Amnesty Unit was equally transformative. Under his stewardship, the unit recovered 68 billion rand in offshore assets, secured 2.9 billion rand in levies, and expanded the tax base by 1.4 billion rand, a feat that set a global benchmark for financial accountability. In academia, he served as a visiting professor at prestigious institutions, shaping the minds of future legal leaders. His editorship of the South African Judicial Education Journal ensured that judicial scholarship remained vibrant and accessible, fostering a culture of continuous learning within the judiciary. What distinguishes him the most is what he chose to do after he rose to the highest court in the land. In 2018, while on long leave from the Constitutional Court, Justice Madlanga offered lectures at two historically disadvantaged universities in the Eastern Cape, Walter Sisulu University and the University of Fort Hare, where he taught constitutional law. Justice Madlanga understands that the legitimacy of our constitutional democracy depends on who gets to participate in it. He has consistently challenged the legal profession to confront the uncomfortable. He has called out the gatekeeping that bars graduates from disadvantaged universities from entering the profession, and warned that unless transformation centers the most marginalized, we are merely rearranging privilege, not dismantling it. To those who have had the privilege of working alongside him, Justice Madlanga is more than a judge. He's a mentor, a guide, and a friend. His chambers were a sanctuary for many young law clerks whom he nurtured with patience and wisdom, taught them not just the law, but the values that underpin it: integrity, diligence, and above all, justice tempered with compassion. To his colleagues on the bench, he's been a pillar of strength, a jurist with a sharp intellect, matched only by his humility. And to me personally, he has been a brother in arms, a confidant, whose counsel I've relied upon, whose friendship I cherish, and whose legacy I will forever admire. Justice Madlanga, this is not goodbye, but au revoir until we meet again. Your journey in service most certainly does not end here. It simply takes a new direction. We have no doubt that wherever you go from here, you will continue to influence the future of our judiciary and our nation positively. And as this court, we hope that you will not be a stranger. This will always be your home, and you will always be welcome back with wide open arms, or at least as long as I'm here. You have done a good job, and I have no doubt that your mother and father are smiling with pride where they are. We are. Thank you. We shall now invite tributes from various representatives of our legal professions and sector, starting with Advocate P. Lay, K. P. Lay, who represents Advocates for Transformation.
Chief Justice, Acting Deputy Chief Justice, members of the court, past and present, members of the judiciary. It is my great honor to rise today on behalf of Advocates for Transformation to pay tribute to one of our own, Acting Deputy Chief Justice Mbuyiseli Madlanga, as he retires as one of South Africa's most respected and accomplished jurists. Justice Madlanga's journey is hugely inspirational. Born in the rural Eastern Cape, he rose from humble beginnings to become one of the most respected legal minds in our country. Justice Madlanga has often spoken about how his early experiences, shaped by the injustices of apartheid, instilled in him a profound sense of fairness and a deep empathy for the marginalized. These qualities would later define his approach to the law during his tenure on this court. Before his appointment to the bench to this court in 2013, Justice Madlanga had already established himself as a formidable advocate, one committed to the transformation of the profession. He served as an acting judge in various courts, including the Supreme Court of Appeal, and was appointed as the chief evidence leader for the Marikana Commission of Inquiry. These various roles equipped him with a broad perspective on the law and a keen understanding of the challenges facing our society. From landmark judgments on property and land rights to decisions on governance and accountability, from safeguarding gender equality and family rights to streamlining our democratic processes. During his tenure on this court, Justice Madlanga has significantly shaped the legal landscape of our nation. A golden thread running through his judgments is an unequivocal commitment to placing the constitutional ideals of human dignity, equality, transformation, and access to justice at the forefront of the law. Chief Justice, you've dealt with some of Justice Madlanga's judgments, and I don't intend to repeat it, save to touch on perhaps 2 or 3 judgments. The first is the obvious New Nation movement judgment. The import of this case, Chief Justice, is that it underscored that the Constitution's vision of government truly includes we the people in all our diversity. This was a bold affirmation that political rights belong to the people and not to political parties. And it compelled Parliament to amend the law to ensure that no citizen's voice is excluded from the national discourse. In doing so, Justice Madlanga reinforced the principle that our democracy must be broad, inclusive, and responsive to the will of the people. Justice Madlanga has also demonstrated himself to be scrupulously fair and even-handed. He has spent countless judgments, like the Nkasana judgment, in which he has been unwavering in demanding that the repositories of public power be accountable and adhere to the rule of law. At the same time, Justice Madlanga has also sought to ensure that those who exercise public power are treated fairly and with dignity. In his judgment in Turnbull Jackson versus Hibiscus Coast Municipality, not one of his often quoted judgments, but a crucial one, he made a point of including in his judgment a paragraph in which he raised special caution against litigants resorting to wanton, gratuitous allegations of corruption and bias against public officials. He made the point that particularly in the current climate, such allegations have enormous potential for harm and should only be made if corroborated by facts. Perhaps the most pervasive theme in Justice Madlanga's jurisprudence is his profound commitment to human dignity and equality. Time and again, his judgments have put the lived realities of ordinary people, especially the vulnerable and marginalized, at the center of constitutional analysis. Chief Justice, you've mentioned the Daniels versus Kribante judgment. In that judgment, Justice Madlanga delved into the painful history of black farm workers' insecure land tenure in South Africa. Critically, he placed the value of human dignity at the very center of a property dispute, declaring that ownership cannot be used as a sword to trump the basic human rights of those living on land. What you didn't mention, Chief Justice, is that Justice Madlanga is also a proud feminist. Not only has he spent his lifetime empowering women, and I can attest to that, but he has placed himself at the forefront of that struggle by challenging his fellow judges, particularly men, to self-reflect on the extent of their unconscious bias and how it may impact their judicial function. In 2020, Justice Madlanga authored an article titled "A Feminist Perspective to Judgment Writing," in which he argues that judges' experiences and their outlooks on life were deeply entwined, and that it would be naive to think that just because the country had a constitution and a Bill of Rights, that these experiences would no longer influence their decision-making. He raised the fact that patriarchy and sexism and misogyny, and I would add racism, were very much a part of the judges' experiences and would continue to be ingrained in the thought processes of some, if not most, judges. Justice Madlanga has relentlessly pursued this crucial yet enormously sensitive topic in many public addresses and interviews, demonstrating not only his courage, but his intellectual leadership. We hope, Chief Justice, that despite Justice Madlanga's departure, that this critical conversation will continue within the judiciary. Through all of these efforts, Justice Madlanga's work has embodied the Constitution's promise of transformative constitutionalism, the idea that law must be a tool to transform society from its unjust past to a future grounded in human rights and equality. Whether it was a poor farm worker defending her home, a bereaved partner seeking recognition, or citizens fighting for a voice in elections, Justice Madlanga's judgments have given practical effect to the noble ideals of our Constitution. He has made the courtroom a place where abstract rights are made real for those who need them most. Justice Madlanga's contribution to South African law will resonate for decades to come. Through his judgments, he has breathed life into the values of our Constitution, reminding us that law is ultimately a tool to achieve fairness and to achieve humanity, and most importantly, to achieve social justice. He has vindicated the rights of the downtrodden, held the powerful to account, and eloquently articulated the constitutional vision of a society founded on human dignity, equality, and freedom. His legacy is inscribed in our law books, in decisions that students will read and that lawyers will cite whenever they argue for the protection of fundamental rights and justice for all. And he has done all of this while maintaining unfailing humility, courtesy, and respect towards others. A jurist of excellence and integrity, a person who carries the weight of his office with humility and a constant willingness and commitment to serve. Justice Madlanga, on this important occasion, we dip our hats to you in deep affection, respect, and gratitude. We wish you well as you embark on your latest endeavor, which may well be guiding our country through one of its darkest times. Thank you.
Thank you, Ms. Pillay. And now I call upon Mr. Mama Tuncha of the Black Lawyers Association to step forward.
Good morning, Chief Justice. Chief Justice of the Constitutional Court of the Republic of South Africa, Chief Justice Pandisa Maya, members of the Constitutional Court of the Republic, a special recognition to acting Deputy Chief Justice of the Republic, the celebrant, Chief Justice Madlanga, the former President of the Republic of South Africa, Honorable Thabo Mbeki, the Minister of Justice, Honorable Mamuluko Kubai, the Speaker of Parliament of the Republic of South Africa, Honorable Toko Didiza, the President of the Supreme Court of Appeals, a former member of the BLA, President Mulimela, all heads of our courts present here, members of our judiciary present here, all senior counsel present, and senior members of the profession, of the practicing profession present here. I stand here on behalf of the Black Lawyers Association, an organization that today is proud to stand before this court to offer its well wishes to Justice Madlanga. I stand here, Chief Justice, to join all other fraternal structures and members of the profession to bid farewell to the colorful life and colorful legal career of Justice Madlanga, who marks his last sitting in the Constitutional Court today by delivering a judgment on a long-standing dispute concerning the law of intellectual property between Mr. Nkosana Makate and Vodacom. The BLA was established in 1977, as we are told, to fight against injustices of the apartheid regime, which also manifested itself in the courts of our republic. And in this regard, I wish to recognize former DCJ and one of the founding members of the BLA, Museneke DCJ. It is a proud moment to address you during this gathering and all other former Chief Justices. That system saw black and white lawyers sitting separately in the courts of our republic, in sections that were called Europeans and non-Europeans. That system required black lawyers who were practicing in the city to vacate their offices and leave town after a certain time. I mention these things, Chief Justice, to display a long road we have traveled as a society to see days like this in our lifetime. In 1994, our country obtained freedom or democratic rule through democratic elections. This freedom gave birth to this court, for which you are now living, Justice Madlanga. You join a galaxy of esteemed black lawyers. I say, and I mention Charles Colson, CJ, Ishmael Mahomet, Museneke DCJ, as he then was, Pius Langa, Chief Justice, Sandile Ngobo, Chief Justice, Judge Skweyiya, Toli Madala, and many others who have made an immense contribution to the jurisprudence of our republic and this court. We salute you for the contribution you have made to the profession and to the jurisprudence of our country. Your work is well recorded in the judgments and law reports for future generations to consume and learn. This is how we will remember you as you head towards retirement as the BLA. I'm not going to take myself through a painful road of quoting some of your judgments, because those are well recorded. I'm also aware that you can't critique judgments of this court. as you leave this court, Justice Madlanga, let's remember that Section 38 of the Constitution remains a key element of the South African Constitution's transformative agenda. Our people still live in squalor. Our people have no water. They have no roads. They have no access to health facilities. They have no access to better education. They have no adequate housing. We are longing to see the days of S versus Makwanyane, Grootboom, Subramani in this court. That is what we are longing for, especially as the BLA, that this court must return to that era and live up to Chapter 2 through Section 38 of the Constitution. As I conclude, is this court still a hope for our people? I leave the answers to the practicing profession and members of the judiciary. We wish you well, Justice Madlanga, and hope that you will assist with legal education and training. We are very passionate about training and legal education as the BLA, as you will know. Training of future judges, aspirant lawyers, as you continue to contribute to society. The National Executive Committee of the BLA and the entire membership bid you farewell. Njela Ntle, siyabulela, as you head and retire towards Mount Frere. Of course, you are going to be delayed by the assignment that we are all aware of, but the people of Mount Frere are looking forward to receive you. As I conclude, Chief Justice, and just to assure Justice Madlanga that we will do what the Chief Justice has stated, that we will confront the uncomfortable, as you urged us to do, with no fear or favor. We will speak on briefing patterns. We will speak on empowerment. We will continue to fight. And I'm sure, Justice Madlanga, you know why I'm making these submissions. We are waiting for answers as we continue to speak the uncomfortable, as the court pleases.
Thank you, Mr. Mama Tunja. Mr. Motlowong, Nadel.
The Honorable Chief Justice of the Republic of South Africa, Chief Justice Mandisa Maya, the President of Supreme Court of Appeal, Honorable Justice Mulimela, Judges President here present today, members of the judiciary, allow me to stand on the already established protocols and offer tribute on behalf of Nadel. It is a distinct honor to appear this morning on behalf of the National Association of Democratic Lawyers to pay tribute to one of our own, child of and son of the soil, the acting Deputy Chief Justice Madlanga, upon your retirement from the bench. I wish to echo the sentiments expressed by previous speakers regarding your numerous achievements and exemplary years of service, including your distinguished practice as an advocate, which was renowned for your intellectual acumen and advocacy skills. Your invaluable contributions to our association, in particular NADEL, and your esteemed tenure as the justice of this constitutional court is something that we are all familiar with. We stand here this morning boldly celebrating the contribution and achievements that you've made to the legal profession. Justice Madlanga, your retirement today, after a sterling 17 years of dedicated service to the bench, is a culmination of a long and distinguished career in the law. It is a testament to the respect that you command that so many current and former distinguished members of the judiciary are present here to farewell you today. Indeed, the retirement of such a juggernaut and a legal beacon is a momentous occasion that deserves grand celebration and appreciation. Justice Madlanga, we celebrate your unwavering commitment and dedication on the bench, recognizing your invaluable contribution to the judiciary. Being a judge in a democratic South Africa is not a career pathing exercise, but it is an opportunity to broaden the horizons of the Constitution to ensure progressive realization of rights and the creation of progressive jurisprudence. Your commitment to justice will be remembered and cherished by all. You carried your work without seeking acclaim or to advance selfish ends. You have, without any shadow of doubt, over the years discharged your judicial duties and functions with distinction. In your pervasive career serving the judiciary, you have wielded both flanks of the judicial system with skill and benevolence. Your judgments reflect a deep understanding and encyclopedic knowledge of the widest range of our laws. In the matter of Daniels in particular, it was an Esther-related matter. This court acknowledged the need to balance the occupier's right to security of tenure and human dignity with the owner's property's right. And since this judgment, some Esther occupiers, without prior consent to engage meaningfully with owners or persons in charge of the land, have improved or erected new structures where they live. Those who know you appreciate the ferocity of your work ethic, your keen eye for detail, and the thoroughness of your approach. Your judicial method left no stone unturned. Your commitment to imparting knowledge of skills to legal practitioners throughout the country is something that, as the National Association of Democratic Lawyers, we are appreciative of. How can I forget your commitment to imparting skills to Free State practitioners by accepting an invitation to give constitutional litigation seminar in Bloemfontein in 2019. This is a demonstration of your commitment to ensure that legal practitioners are upskilled. South Africa's history is marked by a struggle against oppression and injustice. Today, we should reflect on the profound journey of justice and democracy in South Africa. Our nation's history is a testament to the resilience of the human spirit and the relentless pursuit of equality and freedom. As NADEL, we remain committed to the transformation agenda and the vision set out in the Constitution of the Republic of South Africa. We affirm our adherence to the principles of non-racialism, non-sexism, freedom, democracy, equality, justice, and fairness. NADEL, on behalf of all those whose lives have been and will be touched and inspired by you, expresses deepest gratitude to you for your service, leadership, and unwavering commitment to justice. We wish you a retirement filled with joy, fulfillment, and well-deserved relaxation. May your distinguished legacy endure the generations to come as a source of inspiration for all. The jurisprudence of this court is richer for your efforts. With those few words, thank you.
Advocate Nhlapo Merabe of the General Council of the Bar.
Chief Justice Maya, Acting Deputy Chief Justice Madlanga, Justices of the Constitutional Court, with your leave, may I incorporate all protocol that has already been observed for the sake of brevity without amputation. From rural Njinjini outside KwaBhaca in the Eastern Cape, hailed Mbuyiseli Madlanga, who would later ascend to be the acting Deputy Chief Justice of the highest court in our land, serving it with admirable distinction and dedication. Justice Madlanga's judicial career traverses over 2 parts, and in my millennial opinion, this is simply epic stuff. For the first part commenced in 1996, when in our toddler democracy, Justice Madlanga was elevated to the bench at 34 years of age, making him the youngest member of the South African judiciary at the time. Phase 2 was when destiny brought him back to the Constitutional Court in 2013, because one cannot escape greatness when it has been bestowed upon them. His incisive and cutting-edge judgments bear testament to this, such as the Bwanya versus Master of the High Court and Helen Suzman Foundation versus the Judicial Service Commission, to mention but a few. The General Council of the Bar of South Africa, the GCB, will eternally hold Justice Madlanga in high esteem for his intellectual and academic prowess. The GCB noted approximately 3 years ago, in 2022, that a majority of the judgments penned by Justice Madlanga, at the time there were 21 and the number has since risen, has enjoyed unanimous concurrence, a further testament to his excellence in leadership and, dare I say, persuasive skills. In addition to all these attributes, Justice Madlanga holds an important judicial philosophy. On 27 August 2020, when he was interviewed on an online platform titled Anchored in Law, Justice Madlanga, and when asked how he would describe his judicial philosophy, Justice Madlanga replied that it is a philosophy deeply rooted in justice, or a sense of justice. He acknowledged that the law does not always coincide with justice, but a judge should move or be motivated by doing justice between person and person. When responding to what would be his most significant contribution to the law and pursuit of justice in his 2022 JSC nomination, Justice Madlanga's response was, and I quote, "I truly contend when at the conclusion of a matter, I feel justice has been done. I say this not as a cliche, because even if our approach to the law cannot be faulted, not everything we do has just outcomes. The law does not always coincide with justice. I believe that I have an instinct for what is justice, and that is what motivates me in my exercise of the judicial function. Many times, that intuitive reaction has helped make a difference and bring about just outcomes where it matters most. And that is in the lives of the vulnerable and marginalized. This, Justice Madlanga, is the legacy that you leave us with. That where justice can and should prevail, it must. From the General Counsel of the Bar, Ndlelanhle, Khadebe, Bungani, Zikode, Gobizembe, Makhulukhulu, Enkosi, thank you.
I shall now call upon Dr. Chabedi SC of the Legal Practice Council to come forward and deliver their tribute.
Not Dr. Chief Justice. It got, yes. Honorable Chief Justice Mandisa Maya, our guest of honor, Acting Deputy Justice, Chief Justice Mbuyiseli Madlanga, the esteemed members of the judiciary, including justices of the Constitutional Court, justices of the Supreme Court of Appeal, judge presidents of all our provinces, judges of our high courts and magistrates, esteemed members of parliament and various state organs, colleagues in the legal profession, distinguished guests, might I mention His Excellency, Mr. President Mbeki, the Honorable Minister of Justice, Minister Kubai, former Chief Justices, Deputy Justices, former Justices of this court, all protocol observed, as they say. On behalf of the Legal Practice Council, I wish to express our sincere gratitude to the Constitutional Court for the invitation to participate in this special sitting. It is a privilege to be part of this momentous occasion as we honor and celebrate the remarkable judicial journey of Justice Madlanga. It is fortuitous that it was a day after today, 12 years ago, 1 August 2013, that Justice Madlanga left the profession, lifted directly from the Marikana Commission, where as senior counsel at the time, he served as evidence leader with some of our esteemed colleagues present today to become a judge of this court. I was also part of the teams that were representing government at the time, and it was an honor to work alongside Justice Madlanga as senior counsel at the time. Today, as the judiciary says goodbye to him, applauded on the sidelines by most of us, Justice Madlanga descends from his position as acting Deputy Chief Justice of this court to once again join a commission of inquiry, this time with a louder and much, what can I say, controversial task laying ahead of him, and this time leading the commission as the chair. What a moment in history. As a person, Justice Madlanga loves a good laugh, but some of us that have always been his juniors, we've never known exactly what he was laughing about, but I guess Advocate Nzevesa SC, who was always huddled at a corner with him, and then you'll hear a booming laughter. He will be able to share those jokes. Unfortunately, as I stand here on behalf of the Legal Practice Council, we do not have a sense of humor, but we are just here to celebrate your journey. What is happening today is a testament to Justice Madlanga's career of excellence, resilience, and unwavering commitment to South Africa's constitutional values in service to its people. His journey through the legal profession has served as a powerful example of what is possible with intellect, integrity, and dedication where it converges. His path has inspired countless practitioners, especially those from disadvantaged backgrounds, to pursue justice with courage and conviction. Throughout his judicial tenure, Justice Madlanga has consistently demonstrated a deep understanding of the law as a tool for transformation. I will not go, the Chief Justice has already set out the judgments that have set a different path for jurisprudence in South Africa. His judgments have illuminated the importance of interpreting legal principles through the lens of human dignity, equality, and constitutional integrity. His work challenged outdated doctrines, strengthened democratic participation, and reinforced the independence of our institutions. Beyond the courtroom, Justice Madlanga has contributed significantly to legal education, public accountability, and scholarly discourse. His leadership and advocacy have helped shape the intellectual, ethical foundations of our legal community. As he steps down from his role as acting Chief Justice, we reflect not only on his legacy, but also on the values that he has championed and repeated by those who spoke before me: dignity, equality, independence, and justice. Independence, I underscore that. That's a value that I personally learned from Justice Madlanga. His career has been a beacon for many in the legal profession, reminding us that excellence and integrity are not only attainable, but essential. Justice Madlanga's retirement from the bench marks the beginning of a new chapter in public service. His appointment as the chairperson of the Judicial Commission of Inquiry into the alleged infiltration of law enforcement and intelligence institutions by criminal syndicates is a testament that trust placed in his leadership and judgment. We are confident that he will approach this critical task with the same clarity, independence, and commitment that have defined his career. Justice Madlanga, the Legal Practice Council thanks you for your immense contribution to the legal profession and the judiciary. Your legacy will continue to inspire generations of legal practitioners and judges. We wish you peace, fulfillment, and continued impact in your next chapter. Ke a leboga.
Thank you, Ms. Chabedi, and now I invite Advocate Sikakane, SC of the Pan-African Bar Association of South Africa.
Chief Justice, Justice Maya, Acting Deputy Chief Justice, the celebrant today, Budrasel, Mbuyiseli Madlanga, former Chief Justice, my homeboy, Mbuyiseli Raymond Zondo, former Deputy Chief Justice, Msenege, former President, President Mbeki, my sister, Togo Didiza, the Speaker, and my sister, the Minister, and all judges present and magistrates present here, and colleagues and everybody, Nabo Khatebe. Khatebe, ngicabanga ukuthi kufanele sisho okokuqala ukuthi sizindondo ngiyifuba, siyaqhatsha, siyazidla umsebenzi owenzile. Ngicabanga ukuthi indima oyikhathulile kwezomthetho nezokuba umahluleli ikhombise abantu ukuthi ukuba umahluleli ezweni elikhululekile kuyini, nokuthi umkhombandlela walaba abaphethe abamajaji ekwenzeni ukuthi inkululeko yabantu ibe yilokho eyayifanele ibe yiko. I'm going to quote you in order to celebrate you, not your judgment, but I'm going to quote a statement that you made on the 17th of November 2019, in an important paper that I think generations will have to read about diversity. Of course, you quote and borrow from the dissenting judgment of Justice Thurgood Marshall in it, and you say this: imagine a man of extremely limited means. He shares a small apartment with his family, his wife, his mother, his sister, and his 2 small children, one of whom suffers from cystic fibrosis. His wife stopped working because of her pregnancy, and is now focused on caring for the sick child. The man was fired from his job as an insurance agent when the insurance premiums he collected were stolen from his home. When he was unable to make up the sum, his former employer filed a claim against him. Although he has since diligently looked for work, the bad reference from his former employer has made it impossible for him to find another steady job. His family survives entirely on public assistance. His only assets are the clothes he wears, some essential household goods, and a couch in storage. This man desperately seeks to file for bankruptcy, including discharge of the debt he owes to his former employer, so that he and his family can make a new start in life. Due to his poverty, however, he cannot afford the filing fee, which you describe as the filing fee as comparable to the revenue stamp that was used to be required when filing summons or an application. He cannot pay it as a lump sum. He cannot pay it in installments. He cannot borrow money to pay it. He is utterly without options. Close quote. I say this is an epic definition of diversity because in this article you grapple with diversity. And you have brought that in this court. And diversity not because of race or class only, but because diversity means the accommodation of different modernities and different epistemic traditions into a court. And you bring that not because you bring your race, because you bring the spirit of your village, of your township. It would not be diversity if you didn't do what you've done so well in the past decades, which is to bring to this court not your race only, not your gender, but the epistemic paradigms of your people in the village. Because diversity would mean nothing if the new assimilated into the cognitive traditions of the old. All we would be is just a group of people, different colors and genders, but all swallowed in Eurocentric approaches of ways of being and ways of seeing. And you have brought that. You have brought to this court something we will be proud of. Dissent, frowned upon by many. But Pius Langa told us that the world was moved by those who dissent, the lone voices. And we as the Pan-African Bar Association appreciate what you've been to this court. We hope that your retirement, which is usually splendid solitude, for one to do the things they have not been doing, for one to reflect, and for one to seek forgiveness for errors that they've made in the stormy ways of life, and sometimes to seek purgatory before they go to heaven. Well, I don't know about you and splendid solitude. You're standing right now at the feet of the beast into whose belly you're about to jump. But your qualities that we celebrate today will stand you great. Those qualities of humility, the ability to listen to others. Most of us like the fact that in this court, in you and others, we found people with our common epistemic backgrounds who could see when we were upset, who could sympathize with us, and we were not invisible to them. You loved the poor, you worked for them, because poverty is not the absence of resources and money, it's the absence of dignity, being invisible, to those who dominate the discourse. Lastly, I want to say to you, Mkulu, you may not be religious, but I know Mbuyiseli. I want to close with a quote by Winfrey Phipps for you, which says this: "It is in the quiet crucible of your personal private sufferings that your noblest dreams are born, and God's greatest gifts are given in compensation for what you've been through." And with those words, I want to thank you, Nohatebe, and everyone, Nosisi, and everybody, because in you we saw a reimagined South African with an ability to unlearn wrong things that we were taught about each other. We want you to hambe kahle, and please fight the beast that in whose belly you are about to jump. Thank you.
Thank you for those valuable reminders, Mr. Skakane. May I now invite the National Director of Public Prosecutions, Advocate Batoyi.
Thank you, Chief Justice Maya. Acting DCJ, Justice Madlanga, Ex-President Mbeki, Minister of Justice and Constitutional Development, Minister Kubai, esteemed members of the judiciary, past and present, colleagues in the legal profession, members of the media, distinguished guests, ladies and gentlemen. We gather here today not to merely mark the end of a judicial term, but to recognize a lifetime of principled service and to acknowledge the contribution of Justice Madlanga and what he has made in terms of the preservation of the rule of law, which is being stress-tested globally, and sadly, we are no exception. Justice Madlanga has brought to the Apex Court not only intellectual distinction, but also, as we've heard so much today, about his deep humility and humanity. I had the honor of working with Justice Madlanga way back in 2007, then as senior counsel that he was. We were part of a 4-person team set up by the then acting National Director of Public Prosecutions, Advocate Mshe, to review and provide an opinion on the strength of the corruption case against then National Commissioner of the Police, Commissioner Celebi. Through his conduct, Justice Madlanga demonstrated that one can be brilliant without arrogance, principled without rigidity, and powerful without being overbearing and domineering. He has reminded us all that the rule of law is not an abstraction. It is a living commitment to fairness, to accountability, and to justice for all. A prosecutor's mandate to upholding justice without fear, favor, or prejudice is hollow without a judiciary that protects constitutionalism, defends the independence of institutions, and ensures that power, whether public or private, is exercised within the bounds of law. Justice Madlanga has been one of the most steadfast defenders of that vision. Through his judgments, which we've heard a lot about today, through his legal philosophy and his unwavering integrity, he has also strengthened the constitutional framework within which institutions like the National Prosecuting Authority operate. Notably, in his 2018 judgment, which Justice Maya referred to, Corruption Watch and others, Justice Madlanga recognized the need for a stable National Prosecuting Authority. He decried the damage that unending instability faced by the NPA at the time, and might I add, in the throes of state capture, could bring not only to the office of a national director, but also to the National Prosecuting Authority as an institution. His decision was informed by the need to ensure that NDPPs have the necessary fortitude, resilience, and character not to be swayed by exorbitant settlement offers. Whether in matters of institutional independence, executive overreach, or prosecutorial accountability, Justice Madlanga has stood firm in defense of the Constitution. He has understood that the rule of law does not merely restrain unlawful power, it empowers institutions to perform their functions effectively without political interference or intimidation. His clarity in articulating the limits of power and the responsibilities that flow from public office has offered a steadfast moral compass, not only for the judiciary, but for prosecutors, police, public officials, and every citizen committed to constitutional democracy. Judge Madlanga, you have reminded the nation and those in power that independence is not a luxury, it is a constitutional necessity. We continue to advocate for the NPA's financial and operational independence, which the Minister is supporting and addressing, and this is a strategic imperative which most likely resonates with the judiciary. I know Judge Zondo definitely, which has pursued its operational independence for several years and which has advanced most significantly under the current minister. In ensuring that justice is served and the rule of law, which is a pillar of our constitutional democracy, is strengthened, the prosecution does not act alone. It requires that the entire system works and that justice and accountability wins at the end of the day. And in this, the judiciary plays a critical and pivotal role. This was very recently illustrated by the decision of the Supreme Court of Appeal in State versus Tabete and others, the so-called Nulane case, one of the first state capture matters that the NPA prosecuted. In brief, as this august House will recall, the High Court judgment in this matter resulted in the acquittal of the accused. The court ARCO claiming in one of its many scathing comments that the prosecution had committed a comedy of errors. Following the judgment, the NPA's reputation was trashed by clickbait-happy journalists and analysts. 6 weeks ago, the SCA overturned this judgment. It found some of the court's ARCO's findings to be baffling, irrational, and inexplicable. It regarded the acquittal of the respondents to be unfair to the prosecution and a decision that compromised the administration of justice. Put differently, and drawing from your judgment this morning, Judge Madlanga, the trial court failed in its duty of proper consideration. Such decisions have a devastating impact on the rule of law, which you hold so dear, and many of the justices present, if not all. The SCA judgment has somewhat restored the confidence in the rule of law. As prosecutors, we rely on the firm resolve of an independent judiciary to ensure that cases move swiftly through our courts, whilst ensuring a fair trial. Fair not just for the accused, but also for victims and witnesses. And in the case of corruption, the country is the victim. In your important final judgment this morning, Judge Madlanga, you once again emphasized the importance of a fair trial. Both our apex court and the SCA have pronounced on this, holding that fairness is not a one-way street, conferring an unlimited right on an accused to demand the most favorable treatment, but it also requires fairness to the public, as represented by the state. This does not mean that the accused's right should be subordinated to the public's interest in the protection and suppression of crime. However, the purpose of a fair trial provision is not to make it impracticable to conduct a prosecution. We've heard much about your efforts in training and empowerment, Judge Madlanga, and I want to thank you for participating in the NPA training that we organized with the Bar Council. You were kind enough to participate and provide guidance on how prosecutors need to be meticulous and objective in decision-making, and which was particularly insightful, given that you yourself are a former prosecutor. As you conclude your term, Judge Madlanga, you do so with immense gratitude of the nation. You have contributed to the protection of our institutions, which you will continue in your work as the chair of the upcoming Commission of Inquiry into Criminality, Political Interference, and Corruption in the Criminal Justice System, which will become known as the Madlanga Commission. The criticality of this commission cannot be overstated. Corruption and unethical conduct has infected too many corners of our institutions in the criminal justice system. Also oversight bodies and the very structures meant to protect us. As it is said, in every crisis there's an opportunity. and I would urge that the Commission does not wait until the end of its work to refer matters for criminal investigation, which will help us clean up our institutions and rebuild them to properly serve the people of our country. We need to rebuild the social compact where trust is restored, corruption is rejected, and we all play a part to create a safer, fairer society. On the behalf of the NPA, Judge Madlanga, I want to thank you for everything, for all your contributions. On behalf of the people of South Africa, you've given us powerful jurisprudential foundation to build upon, and your legacy will continue to be a guiding light. I thank you.
Thank you, Advocate Batoi. And now the Minister of Justice and Constitutional Development, Ms. Kubai, MP.
Thank you very much. Let me acknowledge Chief Justice Madlanga, former President Thabo Mbeki, the Acting Deputy Chief Justice Mbuyiseli Madlanga, our celebrant, current Justices of the Constitutional Court and former Justices, President of the Supreme Court and Justices of the Supreme Court of Appeal, heads of courts and all members of the judiciary, the National Director of Public Prosecution, Advocate Batoi, legal practitioners, ladies and gentlemen. It's a great honor for me to be part of this very auspicious occasion among very distinguished jurists, legal practitioners, legal scholars, and leaders to mark the retirement of a distinguished jurist on behalf of the executive arm of the state. It is always difficult to do justice when one pays tribute to a person who has done so much for the legal profession, the development of jurisprudence of the country. On behalf of our government, let me take this opportunity to thank you, Justice Madlanga, for the distinguished service you have rendered for our country. The people who have gathered here and those who joined us last night at the dinner in marking your retirement are a testament to the important role you have played in the strengthening of our constitutional democracy and marking our country a more just society. As we gather here, we're marking your retirement as well as we know that is not really a retirement, but just a step off for a second and into another role, as everybody has been saying last night as well. But we're marking an era, an end of an era in terms of service to humanity and to another. You might have delivered your last judgment today, but I know as a matter of fact that this is not the last time that you are going to weigh the evidence, listen to witnesses, and deliver a decision in many areas. The years that you have spent in the bench interpreting our laws and ensuring that the South Africa of today and tomorrow is more just society than the South Africa of yesterday contributed to a vision that was conceived 17 years ago that said in the Freedom Charter, all shall be equal before the law. You served in the Constitutional Court for the 5 years, but in the capacity you authored just under 60 judgments, overwhelmingly. Your judgments are either anonymous or command the majority. The judgments relate to many of the weighty issues the court has pronounced upon in our constitutional democracy, such as the implications of the Constitution for contract law and for marriages concluded under customary law, the duty of Parliament to facilitate public participation in legislative processes, the constitutional privilege for free speech and immunity from arrest of members of Parliament, the obligation of the IEC to record voters' addresses on the voters' roll, the entitlement of candidates to stand for election to public office without being attached to a political party, the constitutional right of a farm worker, Ms. Daniels, to effect improvements to her modest home to make it habitable in the absence of the landlord or the landowner's concern, This judgment, Justice Madlanga, graphically describes the pain, indignity, and injustice of land disposition in South Africa, an open wound that occupies the center of our constitutional democracy today. Justice Madlanga carried out his responsibilities with the understanding that our country has a past which was characterized by injustices that have shaped our present and will continue to shape South Africa's realities for a foreseeable future. Thus, his judgments have lived to the preamble of our Constitution, which says, I quote, "We, the people of South Africa, recognizes the injustices of our past, believe that South Africa belongs to all who live in it, united in our diversity. We therefore adopt this Constitution as the supreme law of the Republic, so as to heal the divisions of the past and establish a society based on democratic values, social justice, and fundamental human rights." In the few months I've worked with you, Justice Madlanga, directly, I've learned a lot, but most importantly, observed how you pay attention to details. Your precision in every task you take or embark upon is remarkable. As Chief Justice Maya said last night, you led a successful celebration of 30 years of our Constitutional Court. I must say, Chief Justice Maya, Acting Deputy Chief Justice has earned a nickname in my team of being a Duracell, working with energy and esteem that doesn't run out. Your work ethic and humility that allows you to work with anyone, irrespective of their title or the office they hold, is remarkable. You are indeed a rare breed, and they don't come often with such qualities. As I have already mentioned, your retirement here today just means you're going to serve your country from a different institutional arrangement. I know that when your country calls you to serve, you will do so without hesitation, as you have already done. As I sit down, let me quote Nkwame Nkrumah, who said, "Those who would judge us merely by the heights we have achieved would do well to remember the depth from which we started," unquote. You are a testament of a journey of perseverance, discipline, dedication, hard work, but most importantly, loyalty to your country. We wish you well in your future endeavors. Once again, thank you very much for your contribution. Khatebe, Bungani, Mtimkhulu, Diabulela.
We concur, Minister. Thank you. And now I grant the man of the moment his right of reply, if any.
I will not do what I usually do today. I will do the protocol properly, and this will be for the first time. His Excellency, former President Mbeki, Minister of Justice and Constitutional Development, Honorable Ms. Kubai, MP, Chief Justice Maya, seated right next to me, the President of the Supreme Court of Appeal, Justice Mulimela, Deputy President of the Supreme Court of Appeal, Justice Zondi, Justices of the Constitutional Court and the Supreme Court of Appeal, Judges President and Deputy Judges President, esteemed members of the judiciary, retired Chief Justice of the Republic of South Africa, Justice Zondo, retired Deputy Chief Justice Moseneke, and all the retired justices of the Constitutional Court, retired Deputy President of the Supreme Court of Appeal, Justice Petse, Advocate Ntsebeza SC, Judge of the African Court on Human and People's Rights, National Director of Public Prosecutions, Advocate Patoi, heads of Chapter 9 institutions, Acting Secretary General of the Office of the Chief Justice, and other Directors General present here today, members of the legal fraternity, and distinguished guests. I should greet my family as well. Good morning. I still can say so. It's just before 12 midday. Let me start with more thanks in addition to those of yesterday. I want to thank my colleagues who were in the committee that organized yesterday's and today's ceremonies. Yesterday, everything was simply amazing. Colleagues, many thanks. I also want to thank all colleagues who spoke at yesterday's dinner. Their speeches were touching, humbling, and wonderful. Colleagues, you all made me emotional. This is true of even brief interventions by Justice Zuki Chikri and Justice Steve Majid, who were not speakers, but only the program directors. And also of Justice Kolapen, who proposed the toast. Hearty thanks, my dear colleagues. Mandy, you did the same today, and I have no idea how you did so. The two moving speeches were not identical, and yet they were quite substantial. I am not ashamed to say publicly that today you brought tears to my eyes. Anybody who was looking would have seen me shielding my eyes with my hand. Ndibulela okungazenzisiyo kungani. To you, Minister, and all other speakers of today, if only I had 1,000 mouths, I would be able to say a much better thank you. My one mouth is simply not enough to thank you. In my language, let me say in this Swahili milomo, yanga ngeili waga. Let me say this to Advocate Moses Kakane SC. This comes from religious text. You seemed to doubt that I'm religious. Kia leboga ho lona kaofela. Yesterday, I thanked veteran attorneys who, through a steady flow of briefs, helped establish our practices and mold us young practitioners into the lawyers we eventually became. One such veteran attorney to whom I must extend words of gratitude is Ubudumisa Ntsebeza, who was an attorney then, but is senior counsel now, and a justice of the African Court on Human and People's Rights. He cared for our growth. He went out of his way to make sure that that became a reality. Diabulela mzala wam, dibamba ngazibini tuse. Now, my chambers. Over the years, I have had many law clerks. I see some of them there. What a wonderful lot of brilliant, highly intellectual, challenging, engaging, tolerant people who would very politely tell me sometimes that my reasoning was nonsensical. Team MRM, as I call them, you made my work so much lighter. You helped infuse quality in whatever I produced. I say you were tolerant because I am a hard taskmaster. I would give you deadlines that were sometimes near impossible to meet. You always did your utmost under most challenging circumstances. I would give you instructions at the oddest early hours of the morning, sometimes saying, give me your responses when you arrive at work. To my surprise, you would sometimes respond during those crazy hours. Many, many, many thanks to you. And now, the executive assistant, who before that title was my PA for many years, Usbongile Dube, whom I call Sbo. Sbo, I will miss your fussing over me. I will miss the way you babysat me in and outside of the chambers. Whenever I would be going on assignments outside of chambers, Sbo would go ahead of me to make sure that I would arrive to a welcoming environment. And sometimes she would embarrass me by making demands on the people who would be receiving me and say, do you have a holding room for the acting Deputy Chief Justice? Do you have this, and so on? Of course, it was well meant. Sbo, you have been the best PA and executive secretary I could ever have wished for. Sbo is known by every member of my family, and she also knows all of them. My children love her, and they call her Mama. 2 days ago, one of them said, Tata, we must organize a party for Umama Sbongile. You can't just part ways without a party for her, close quote. Ubonga kakhulu, kakhulu kakhulu Sbo, nangamso gesinto. To my family, I thanked you yesterday, but let me, in one word, do so again and say I am truly grateful to have you as my family and as my support structure. Thank you very much. And let me address myself directly to my aunt, Auntie Wam, who is the last born child in my mother's family. Auntie, you are our only remaining parent, our only mother, and you play that role. Thank you very much, Auntie. And where did it all start? The Chief Justice mentioned it. She actually quoted me on what I said about how I came to study law. It started with my parents, in particular my father, who directed me in the direction of studying law. It was a good direction, I think, because I think if he was still alive, he would have been very proud of the achievements that I have managed to attain. Likewise, my late dear mother, she also was a very important support structure in my formative years, and indeed even in my later years. Nurturing, loving. So without those beginnings, without that kind of growth under her, without the values that she instilled in me and my siblings, I doubt that I would have become the person that I became. So I'm truly grateful to my parents as well. I might add that probably my father sent me in the direction of law because even though he was not a lawyer at all, no legal training whatsoever, he was somewhat of a lawyer. He was a school principal. And about the lawyering, he really enjoyed attending imbizos where cases would be heard by the entire community. And that is how he too would participate. Those that were on the other side and not supporting his argument were always in trouble because his submissions at those imbizos always ensured that the side he was on won. I remember one occasion, a new headman in our village was against my father in a land dispute in our area. And as usual, my father won the dispute. And he went to that headman and said to him, if you want to be a good leader in this community, you must lean on this shoulder. And he patted himself on the shoulder. That was Ubudvuyani Makaula, our then headman. He is late now. From that day, Ubudvuyani indeed took my father's counsel on many issues, and they became friends. Something else that also demonstrates that with him there was this instinct that was very akin to how a lawyer would act. If we as children had done something wrong and it was not quite clear who exactly was in the wrong, my father, I said yesterday that we were upwards of 20, just the children, not his only. We were only 6 at home. He would line us up and hear the case of each one of us. You would have to defend yourself in front of him. And if he was satisfied with your defense, he would say, okay, stand aside, stand aside, stand aside. And those who did not have cogent defenses would get chastisement. So instinctively, my assessment, but of course this is something that I did this in later years. I think it was that instinct, that love for law that he had, that he then directed me to become or to study law. I am very, very grateful to both both my parents. And lastly, let me say that I am very happy to have been part of an institution that has been responsible for first creating the constitutional jurisprudence of this country and continuing to grow it over the years. I can only hope that in that process I have played my fair share. Well, I believe that I have, because the speeches from yesterday and today suggest that I did. Thank you very much.
Acting Deputy Chief Justice Mbuyiseli Madlanga, colleagues, distinguished guests, where I come from, we say at this stage of proceedings, okungapheliyo kuyahlola. We have reached the end of our program. May I once more extend our deepest gratitude to the Madlanga family, who for this 30 years of Justice Madlanga's sterling service to his country, which we have been talking about this morning, had to share their husband, father, brother, uncle, and family anchor with a nation that needed his wisdom. We recognize that service of that magnitude is never borne by one person alone. The heavy responsibilities, the late nights, the absences from home, these were sacrifices too. Siyabulela Mahlubi kakhulu ngokusiboleka yena. The court has been richer for his presence, and we know that his legacy is as much yours as it is his. To all the speakers who have paid tribute today, your words have painted a portrait of Justice Madlanga, not just as a fine judge and lawyer, but as a man of integrity, a loyal friend, a generous colleague, a peer whose wisdom commanded respect, and overall, a decent human being. Your stories have reminded us that behind the robes and the brilliant judgments is a person of warmth, wit, and unwavering principle. You have reaffirmed what many, if not all of us here already knew, that Justice Madlanga is a jurist of a rare caliber and a human being of uncommon grace. ADCJ Bungani, I think that it would be safe to say that all the words that could have been said about you and have been said, and I dare say that you have a fair idea of what all those who will bury you one day in the distant future will say upon your grave. The tributes that have been paid here this morning have reminded us once more of the depth of your legal mind and the enduring impact of your work. Your voice, sharp, principled, and deeply humane, will remain a guiding force in the ongoing project of justice in South Africa. Uqatso ulufezile mashwabada siyazingca kakhulu ngawe. Siyabulela ngegalelo lakho. In keeping with African culture, there are refreshments out in the foyer. Please do have a sip of water before you leave the building. We adjourn. Thank you.